Now we will turn to a case that's getting a lot of attention in Florida, actually. An 18-year-old high school student facing criminal charges for allegedly having a sexual relationship with a 14-year-old. NBC's Carrie Sanders is in Sebastian, Florida with that story. Carrie, good morning.
Well, good morning, Savannah. The lawyer for the 18-year-old does not dispute the facts in this case. Her client has been expelled from the high school here, and now that teenager faces a difficult decision: accept a plea deal or fight the charges, 2 charges of lewd or lascivious behavior on a minor.
It's okay if you do make a statement, but not about the case.
18-year-old Caitlin Hunt wanted to speak, but when she walked to the microphones, she couldn't find the words. Wrapped in her father's arms, the cheerleader story has become a cause to more than 150,000 online. FreeKate.net, a petition on Change.org, and Facebook posts, all urging the state attorney drop the prosecution. The honor student faces 2 counts of lewd or lascivious battery. If convicted, she could go to prison for up to 15 years, the same as if a boy were convicted of the same crime with an underage girl. And she would be a registered sex offender.
She's been robbed.
Caitlin's parents say they believe the charges resulted because the parents of the 14-year-old cannot accept their daughter had sex with a girl.
This is killing us as a family. And I would just beg for them to look at that and look at the reality of it. Listen to their own child, what she says, you know, and just what's the purpose of this?
Charles Sullivan is an attorney representing the 14-year-old alleged victim and her parents.
This is a violation of the law that's based upon an adult having sexual relations with a minor. The gender, sexual orientation of the parties has absolutely nothing to do with the prosecution.
How are you holding up?
Every day's different. Like some days I'm my happy self, and then some days I'm overwhelmed, some days I'm scared. So it's just kind of like I have my days.
The state attorney has offered Caitlin a plea deal, but her attorney says she would still be a convicted felon and would have to attend sex offender counseling. Her hope now?
Definitely hoping for a better plea deal. But if not, then we'll just have to do everything that we can do to win the fight.
The clock is now ticking. The state attorney has told Caitlin's lawyer they have until Friday afternoon to accept the plea deal or go to court. Meantime, the 14-year-old in this case has now turned 15. Savannah?
All right, Carrie Sanders with a little bit of a lightning issue there. Carrie, appreciate it very much. Let's turn to Lisa Bloom. She's today's legal analyst. Lisa, good morning to you.
Good morning.
Boy, does this case raise a lot of questions, but let's just start with the straightforward application of the law. The fact of the matter is there are statutes in every state in the country that prohibit sexual conduct with a minor, and that minor's consent is not a defense. I mean, is this an open and shut case on the law?
Well, that's right, Savannah. An 18-year-old is an adult in the eyes of the law. And in Florida, if you're 18 and you have sexual relations with a 14-year-old, that is statutory rape. An 18-year-old can drink, can work, can live independently, can sign contracts. A 14-year-old can't do any of that. There's a bright line in the law based on age.
And the reason for that is because the law looks at it and says there's a power imbalance when you're talking about an adult and a minor.
Exactly. And psychologically, there's a big difference between a 14-year-old and an 18-year-old.
But a lot of people look at the facts of this case and they ask, would this be prosecuted at all? Forget that the law's on the books. Would it be prosecuted if not for the fact that this is a relationship between 2 girls?
And that's the question. So I looked at FBI statistics online, and it turns out that 9 out of 10 people who are prosecuted for statutory rape are male, and 9 out of 10 victims are female. Overwhelmingly, it's heterosexual boys who are prosecuted for this. This case seems to be an outlier.
All right, let's talk about what the parents are facing and this young woman, Caitlin. They've been offered a plea deal from the prosecutors, which would mean no jail time, house arrest. She would be a convicted felon, and there would be a chance that the judge could withhold adjudication and she wouldn't have to register as a sex offender. Okay, You're presented with that deal. Do you take the deal? Because her parents aren't so sure she should.
Very reluctantly, if she were my client, I would say yes. 2 years house arrest is a long time, but she's facing up to 15 years in prison. I mean, this is a pretty tough law. She can petition the court under what's called the Romeo and Juliet statute in Florida, which is essentially that she would not be on the sex offender rolls because she's 18. The victim was only 4 years younger than her. It's her first offense. So in the long term, not all that bad for her. In the 2-year short term, pretty bad.
And what's the alternative? If she doesn't take the plea, she goes to court. isn't the verdict going to be guilty because she's acknowledged this conduct? And as we just discussed, the law is pretty straightforward on this.
She really doesn't have a defense. Ignorance of the law is not a defense. I thought she was older is not a defense. The law just looks at the age of these two girls, both of whom have admitted to the police that they had sexual relations.
Very quickly, there's a public petition now, and I think it has something like 150,000 signatures to get the prosecutor to just drop the charges. Is that the kind of thing that can be persuasive to prosecutors?
It can be. The prosecutor has broad discretion here. He can offer a better deal to her. That's within his power. The petition could affect that. If she goes to court, of course, a petition can't affect what a judge would do.
All right, Lisa Bloom, a lot of interesting legal issues and parenting issues, too. Thank you so much.